So what I want to do today is go through a scenario after I've done a bit of an introduction to the topic, and then provide an overview of mental capacity as a concept and talk about informed consent and barriers to informed consent. This webinar on consent is a two-part series. The plan is to have the second part of the webinar in September. And at that time, I will focus on substitute and supportive decision-making and probably also advanced directives. But for this webinar, we're wanting to introduce some of the basic concepts. So my goal for today is that you leave this session with an understanding of the basic concepts of capacity and informed consent, and an ability to apply them to your own work. And also to have an enhanced ability to identify potential legal issues or problems that arise and that might require further research or advice. So my hope is that hopefully in the future, a light bulb will now magically go off in your mind at the right times. And the light bulb is not going to necessarily provide answers. It's probably going to identify questions, but these questions will ideally set you off on the correct ethical path. Looking at the registration list, I see that folks come from very different backgrounds, and I'm assuming today that none of the listeners are legally trained. We really developed this webinar for AgeWell members while opening it to the public, but I noticed in the webinar attendee list, there are some lawyers on the list who have significant knowledge around mental capacity and consent. So hopefully this webinar will be interesting to you as well, but I recognize that it's not being designed really at your level. So apologies if it's not the right fit for you, but there's only a couple of you, I think. So key resources for information when you're thinking about consent and in capacity in your jurisdiction. In this presentation, we're going over legal concepts of mental capacity and informed consent, and it is important to understand that your particular responsibilities vis-a-vis consent and capacity may not be limited exclusively to the law. So I've listed three areas here on the slide. So first, law. So when we say legislation, I'm talking about provincial, territorial statutes and regulations. Most laws that relate to capacity, consent, and substitute decision-making are created by the provinces and territories. This is one of the challenges of working in a nation with jurisdictions. It makes all of our work more complicated. And our function of that is that the laws may vary slightly from jurisdiction to jurisdiction. In this webinar, I will try to stick to legal concepts, so the webinar will apply to everyone's practice. However, in your own work, you will want to be mindful about what laws apply to your work. Things may be importantly different if you work in Ontario versus British Columbia. Further, if you're doing a national study with participants from multiple provinces or territories, things could get more complicated for you. You may want to get legal advice on which laws apply to participants, users, patients, or clients, depending on what kind of participants you're working with. The legal principles that we talk about when we talk about capacity and consent are largely rooted in the common law, which is basically laws formed by judges in the context of court decisions. When we talk about the doctrine of informed consent, this is a concept originally found in decisions by judges. What has resulted is in some jurisdictions in Canada, we now have statutes that codify some of these rules, but generally they are making the common law more clearly the law in their jurisdiction and actually changing it significantly. But some jurisdictions do not have a statute. So in some areas, other than substitute decision-making, where there's laws across the country, in some areas for consent, there's just no statute that applies to your work. So you're turning your mind to what we call the common law. I will try not to quote statutes in this PowerPoint presentation and focus on concepts, as I've said. I think there's one slide with a brief quote. But I want to remind you, I may have said this already, that there are significant differences in provinces across the country, and it's important to know what applies to your work. So you will sometimes need to get legal advice. I'm focused on helping you develop that light bulb. So in addition to laws, it's not just laws that you may need to turn your mind to. You may also want to turn your mind to code of ethics. So consider if you're a social worker, a nurse, a pharmacist, a physician, you may want to consult codes of ethics that apply to your work. You may also want to consult practice guidelines or practice standards developed by your college or subscribed to by the regulatory body. These documents form part of the network of rules and guidelines you are expected to follow in addition to the law. So think of the law as a bare minimum and that you need to do better. Also consider institutional policies. Your university, employer, or other agency you are affiliated with may have created policies that you are expected to understand and apply to your practice. Also, there are broader policies than just institution-specific policies. For example, if you are a researcher, you may be aware of the Tri-Council Policy Statement on Ethical Conduct for Research Involving Humans. So this provides guidelines around consent in terms of participation in research. This is a policy jointly developed by the Canadian Institute for Health Research. You may have heard of them as the CIHR, the National Science and Engineering Research Council of Canada, so that's NSERC, or the Social Sciences and Humanities Research Council of Canada, SSHRC. So this is a tool that's been developed through collaboration, and it may apply to your work and you're as a researcher, even though it's not strictly speaking the law, but it's part of the collection of what you need to be aware of. My colleague Laura Tamplin-Watts has characterized these elements, these three elements that inform your practice in the following terms. She said that policy is what someone else expects, wants you to do. Ethics is what you ought to do. And the law is what you are obligated to do. So in my talk, I'm focusing on the law and providing some practice ideas, but I encourage you in your research to be aware of these other key resources and guidelines that should be informing your work. Oops, I'm having trouble with the PowerPoint. There you go. So I want to say a couple words about the Canadian Centre for Elder Law, which is the organization that I work for. We are a national, nonpartisan, independent research body. We are part of the British Columbia Law Institute, which is BC's nonpartisan law reform agency and is also a nonprofit agency, or in other communities you may call this an NGO, non-government organization. So we are separate from government, but we are a nonprofit. We aren't actually part of a university. I think those two features make us kind of unique in this sector. Our work includes legal research. So we publish studies clarifying the law. For example, years ago, I authored a study on the law related to work and family caregiving. We do law reform work. We work with communities to develop reports making recommendations for changes to the law, policy, and practice. And we work with governments that are interested in implementing our recommendations. As an example of this, we are currently examining healthcare consent law and practice in BC in relation to older adults living with dementia. Next fall, we will be publishing a report with recommendations for law, practice, and education of various healthcare professionals and allied health professionals engaged in this work of prescribing medication or treatment, administering medication, caring for older adults, or folks who are in other ways involved in healthcare consent for older people living with dementia. So we will be happy to share those findings with you in the fall. I suspect we'll do another webinar specifically on that topic. Legal education is a part of our work, and that's a little bit what I'm doing today. We've developed a range of tools to help people understand the law, ranging from videos to fact sheets. And as part of outreach, we often do commentary in the media on legal issues that impact older adults. And I think one of the most relevant recorded ones would be, as part of the Sunday edition, Karen Wells did a documentary on consent that we participated in. So anytime we develop materials to support practice, we put them on our website and they are available for free to you. The last slide of this webinar is going to provide you with our URL so you can look up other resources if it's that helpful to you. Some of our projects are national in scope, some are provincial and some regional. It just kind of depends on the issue and the funding source. Personally, I'm a lawyer by training and a practicing lawyer in BC. I think it's important to disclose that, but I do not represent clients in the traditional sense. So nothing I do looks like The Good Wife or any other TV shows involving lawyers to my knowledge. Maybe someday that will change. In my presentation today, I will provide information about the law, but I cannot give you legal advice about your particular situation. I'm happy to answer questions at the end of this presentation. I think there's a little chat box where you can send questions to Crystal, and then she will read them out so everyone can hear them. I'll leave time at the end so that there's at least 10 minutes for you to ask questions. Since I can't give advice and speak to a particular person's situation, I think it's useful to explore mock scenarios to help ground our understanding of legal concepts. So I'm proposing we start with a story here. So this is Alice. Alice is 82 years old. She has a number of health conditions, including rheumatoid arthritis and diabetes. She's also been living with dementia for 5 years. Alice has been living with her daughter, Eleanor, and Eleanor's partner, Stella, for the last 2 years. Although home support attends to provide some assistance, such as physical therapy, Alice is able to live independently in the community because her daughter provides a great deal of caregiving for her mother. Eleanor cooks meals and does laundry for the family and helps her mother with bathing. Alice is still able to participate in community activities and programs with the Alzheimer's Society and other agencies because Stella and Eleanor drive her to all of her activities. Stella is Alice's attorney under power of attorney. Stella is an accountant and an experienced financial manager, and Alice chose Stella to manage her money because she found her to be reliable and organized when it came to finance. Alice has contacted you because she saw a sign in her community center advertising an opportunity to participate in research. So you are meeting with Alice to provide her with more information on the project and to get her consent to participate. Alice seems like a suitable candidate, but you are concerned with whether she can participate due to her dementia. Can she provide informed consent? If not, can someone else provide consent on her behalf or help her to have enough of an ability to provide consent? Today I'll be talking about the first question around can she provide informed consent. Next session, we will explore the law around consenting for someone else, which is a concept known as substitute decision-making. I will also at that time talk about supportive decision-making, which is a concept with currency in some jurisdictions in Canada. So to start with mental capacity. Mental capacity, it's also called capability in some laws and by some practitioners. Sometimes you will hear the word competency. Essentially, mental capacity refers to decision-making ability. Not what decisions you make, but how you make your decisions. It's really about process. Whether a person has capacity is not determined by disease. A person may not have capacity due to a disease such as Alzheimer's, or due to substance use, impact of medication, trauma, brain injury, mental illness, developmental disability, sleep deprivation, stress. All these factors can impact decision-making processes, but they are not determinative of whether someone has capacity for a particular decision. For example, many people with dementia have capacity to make all or some of their decisions. Importantly, not everyone loses capacity as they get older, or perhaps they just do till at the 11th hour. So the fact that Alice has dementia is not determinative either way whether she has capacity. It's really just part of her story. In fact, other factors could be more relevant in her case to whether she has capacity. The answer to the question of whether she can consent, as with all individuals, requires us to get to know Alice a little better. And of course, it also requires us to understand the law. Many laws across the country have fairly clear statements regarding what it means to have mental capacity. In other instances, we know the principles really they are part of our understanding of what the common law tells us about what is required for capacity. But generally speaking, a capable adult is able to understand information, evaluate the data or information, so link the data to possible outcomes, and appreciate possible consequences. The issue is not what kinds of decisions they make, but how they make them. Are they following some kind of reasoned process? Can they understand the relevant information to the decision that they need to make? A decision that seems odd or risky may be a red flag of a capacity issue, but it might also just mean that this person is comfortable with risk, or they have values that are different from yours. Perhaps in your mind they're a little bit eccentric, but that really isn't determinative of capacity either. All these things are compatible with having enough capacity to make your own decision. Importantly, capacity is decision specific. So if you're wondering if a person has capacity, even someone whose memory may be declining, you have to always ask capacity for what? What kind of decision? What is the particular decision at issue, not just the kind of decision? Consider what information or data is relevant to making this decision. In other words, what do they need to be able to understand in order to make the decision at issue? Different standards apply within the law to different kinds and types of decisions. Standards in terms of what they need to be able to understand. So for example, a person can have capacity to marry, but not capacity to change her will, even though those two actions seem fairly related, because judges have determined that the capacity test for will should be higher. A person may not be mentally capable of signing a power of attorney, giving her son authority to deposit her pension checks and take care of all of her taxes, because the knowledge of her finances that she's expected to have is fairly high, but she may still have capacity to make some of her own healthcare medication decisions, because she's able to talk about how she feels or understand how she feels when she's taking certain drugs. She's able to express a view regarding heroic measures to save her life. Maybe she can still decide if she wants to live in a care facility or at home, or maybe she cannot make that decision because she does not appreciate the risks involved. That said, a person might have no legal decision-making rights because a guardian, in BC we call this a committee, has been appointed by a judge to make all her decisions. But a person's situation is not likely to be speaking with you in the research context anyway. You would be probably dealing with a guardian, the individual and her guardian. And I'm not talking about substitute to consent today. I could have capacity to make my own health and personal decisions, but not to manage my money any longer. Everyone's capacity is unique and they may be capable of different things. Few people will have capacity to make no decisions at all, unless they are completely unconscious or extremely progressed in dementia or some other illness, disease. So capacity to do what? This slide gives you some examples of decisions that will be subject to different legal tests for capacity. Capacity to make a will, to marry, to accept surgery, to be involved in mediation, to enter into a contract, to create and sign a power of attorney, to get divorced, to refuse treatment to medication, to instruct a lawyer, to sell real estate. All these different transactions might have a different capacity standard, and then as you apply to that person's experience is also going to depend on how complex the information is. But under the law, judges have decided that there are different standards for certain kinds of decisions, and some of those standards have been codified in provincial legislation, territorial legislation in some jurisdictions. An important part about understanding capacity is that at law, everyone is presumed capable until the contrary is established. You will find this kind of fundamental statement in laws across the country and applies to adults regardless of age. You'll find this kind of statement in guardianship law, in healthcare consent legislation, in power of attorney legislation, and also in substitute decision-making or guardianship laws. Here on the following slide, I have an example that's a quote from a BC law, the only quote from a statute in this presentation. And this is from the Adult Guardianship Act of BC. To just give you an example of the presumption, it says, until the contrary is demonstrated, every adult is presumed to be capable of making decisions about the adult's personal care, health care, and financial affairs. Capacity is not fixed, and those of you working in social science and healthcare may be very aware of this. Capacity can fluctuate, increase, or decrease, sometimes within a day, a week, or a lifetime. Capacity can be linked to medication. It can also be impacted by a time of day. Some people living with Alzheimer's, for example, will experience late in the day confusion. I think some people use the term sundowning to refer to this experience, but I'm not sure that's a term that's widely accepted as being appropriate in the Alzheimer's communities. One way to look at capacity is as a continuum. People with diminished capacity can be more or less capable at different moments in time. The moment of a decision-making is the slice of time that matters. What capacity do they have now? It's not what they had yesterday or today. If you're asking a person to consider a decision, it's the now that matters. Now, one question I often get asked is, who determines if a person has capacity to make a particular decision? I'm going to offer my view on this topic, and I think you may find that there are some differing views out there. To my mind, there are many answers to this question. If a person's mental capacity is formally assessed, it is likely a healthcare provider of some sort, ideally someone like a geriatric psychiatrist with specialized and relevant knowledge and appropriate training in how to conduct and document a capacity assessment, who is conducting the assessment. Some legislation actually provides for what kind of professionals can conduct assessments. If a guardianship application is in the court system, it is a judge who will make a determination of capacity, but they will make it based on, very likely based on expert medical evidence. So then informed by the physician, the geriatric psychiatrist, the other professional who's providing the expert evidence to inform that decision. However, I would argue that we all conduct informal capacity assessments all the time. So I often make a distinction between that formal assessment the geriatric psychiatrist is conducting and providing to the judge and evidence, and an informal capacity assessment. So just to give you an example in terms of my practice as a lawyer when I was working in private practice, when I represented clients, I needed to know they understood enough about the situation and the information I had provided in order to give me instructions on what to do. I needed to make sure they were not signing a document that they did not understand. At the time, I never thought of myself as doing many informal assessments of capacity, but certainly if I felt that a person did not understand what was happening or what I was saying, I would seek some practice guidance, maybe from a more senior lawyer or someone with my licensing body. I could represent a client with a very serious mental illness who had active delusions at say, for example, a tenancy hearing, so long as it was clear that they wanted to stay in their home and were challenging the eviction. They understood the relevant information in order to give me instructions. But if they were deluded about some other factors, that may not be relevant to whether they had capacity. I would say that every one of us who deals with clients or patients makes many capacity judgments all the time. I think that we have to. We cannot take instructions from someone who does not understand relevant information. But I think we make these assessments all the time without necessarily awareness, because most people, they pass muster. In some contexts, the process is more formal. A lawyer may request a doctor's letter before taking will instructions from an older woman with mild dementia, such as Alice, for example. But that's not the norm. I think it's important to point out that decision-making autonomy is a fundamental right of citizenship. As soon as we become legal adults, we become self-determining, hopefully. We choose our futures. Taking away someone's right or refusing to recognize their right to make their own decisions is an extreme act. Assuming older people or people with certain diseases or disabilities cannot make their own decision can be ageism. Refusing to allow a person to participate in a study because they have a particular disease or because they're older may be age discrimination or discrimination based on disability. We need to check out our biases when we were thinking about capacity. Since we know that capacity can depend on circumstances, I think it's logical to have a bit of a discussion about how to adapt your own practice so as to maximize a person's capacity to make a decision or participate in an activity or study. Or we can talk about the project. So I would say always consider how can your interactions, how can you organize them with a view to maximizing capacity for potential clients or patients. For all clients and patients, or particular patients with special needs that may require accommodation. I think this is a useful lens to think about all of your work. Here, I would say we have a lot to learn from the disability community and basic principles of inclusion and equality. Like, when is it good practice to be confusing and not try to be understood by people? When is it good practice to speak in a way where your language is exclusive? So I've put on these next two slides a few basic ideas about how you can conduct your practice in terms of maximizing capacity, but these are just a few ideas. So, find out what time of day works best for your client. I actually find when I'm presenting to seniors that community agencies say that morning is a good time, the best time for them. So we usually, do our sessions at 10 a.m. Use visual aids or memory cues if it's helpful. It's kind of why we use PowerPoints nowadays. Plan for adequate meeting time so you don't have to rush and can speak slowly and clearly. For most of us, understanding is poorer when we are under stress. And I think, for example, my father has had a stroke recently. And I notice whenever he's trying to communicate with us, because he has a certain amount of expressive aphasia, so language challenges, that he communicates so much better when he doesn't feel under pressure. Just moving on to the next slide. So orient your client at the beginning of the meeting. So make sure they understand what is going on and why you're there and what phase of the discussion are you at if you're having multiple conversations about a topic. Launching into the discussion without much context can confuse anyone. Some people keep food or drink in the office or other things to help people be comfortable. If you're working with a lot of clients who are older and clients who have diabetes, you'll find blood sugar has a significant impact on the ability to participate meaningfully in a discussion. And take breaks as needed. Like if you notice your body language that your client is, or your patient or the potential participant, that their focus is starting to not be as clear, take a break. If you have the time and you don't rush things, you can allow for strategies like this. And I'm sure that in your own experience, you'll have come up with or could come up with other strategies. The point is basically that you can organize your interactions with people in a way that can lift them up or crush them. You can enhance capacity or reduce capacity slightly by the way you organize those meetings. For some of us, we will present with capacity pretty much no matter what. But some people are more susceptible to having their capacity impacted by the surrounding circumstances. Alice, for example, who has dementia, she may have capacity to decide whether to participate in your study, and we don't know yet. But as she has dementia, she may be particularly sensitive to stress and become disoriented with rushing. Again, we need to know Alice a little better to be able to answer these questions about her. The Alzheimer's Society of BC has developed a number of booklets with ideas for you for how to adapt your practice to be more dementia friendly. I've seen similar resources developed by the Alzheimer's Society in the UK, in the US. These are great tools for helping you to use communication strategies that are more inclusive. And I encourage you to check out these booklets. I noticed recently that the Alzheimer's Society of BC published a tool on meaningful engagement with older adults living with dementia. In particular, I thought that was really helpful in terms of thinking about how to support meaningful conversations. So, here we go. Next slide. Any person who has capacity has the right to take risks. They have the right to decide what risks they take with respect to their own body and with their money, so long as their consent is truly informed, which takes us to the second part of this presentation. The basics of consent are something that has emerged from common law, so the judge-made law that I spoke about earlier. And on this slide has three of the fundamental principles of informed consent. So you have to have capacity, the consent needs to be informed, and consent needs to be voluntary. So I'm going to talk about the voluntary and informed piece now. Again, in some jurisdictions, consent in certain contexts, there may be provincial or territorial laws that provide for more specifics or that basically codify the common law. I encourage you to be aware of the laws in your jurisdiction. So what is informed consent? Basically, it is the right to sufficient information in order to make an informed decision. It is the right to ask questions and receive answers. It includes a right to be informed of material risks, bad things that could happen, even if you don't ask for that information, no matter how remote the risk could be. So consider, for example, if you are talking to someone who is an immigrant or someone who has limited English or no English at all, do you need to have an interpreter present? I think always ask yourself that question if you're working with someone for whom English is not their first language. And if you need an interpreter, is the family member who has shown up to drive the person to the appointment an adequate person to provide interpretation? In many instances, a family member is not adequate, both because they are not formally trained in interpretation, they may be confused by technical language, although hopefully you're not doing too much of it, but also because if there's a relationship between that person and their interpreter then, and the interpreter may have their own agenda or views that they aren't even aware of that clouds the objectivity or the literalness of their interpretation. So I would encourage you to always have a budget for professional interpretation if you are working with or representing people for whom English is not their first language. Informed consent requires discussion. It's a process and it takes time. As a practice point, some people will ask a lot of questions. I'm sure my 10-year-old is going to be one of those people. But some people are going to ask very few questions for whatever reason. And for those people, you need to just try to anticipate what they would need to know and provide a reasonable amount of information. A 20-page pile of paper in a 10-point font is not good practice. And I'm sure a lot of us have been to appointments, in particular at a bank, where we were provided with a very big document, with very small font with details, and then we were asked to sign. Often the person will turn to the final page and just presume we have no interest in signing the document and reading the document that we are signing. These are examples of very poor practice. Asking people to sign something they haven't read, that should be an obvious one, but just having a document that's really way too hard to read because of font size or because of detail and length is not good practice. The right to informed consent, the right to consent, includes a corresponding right to revoke consent or change your mind. You can take your consent back, you can discontinue treatment. Consent is ongoing and multi-stage. So you need to always be sure that the person you're working with has provided consent and still wants to participate. The right to withdraw your consent includes a right to be informed of information associated with the risks of withdrawal. So for example, for those of you who are engaged in research, if you have participants who want to withdraw and there are risks associated with withdrawal, you should tell them what those risks are so they can make an informed decision about how and when and if to withdraw from a program. In terms of the right to withdraw from a study or revoke a document, it's important to have your mind around the notion that people can't really bind themselves for the future. They can express an intention, but things happen and people do change their minds. One of the reasons why we see so much elder abuse is that older people often do not appreciate that they have a right to take things back and change their mind and appoint someone different, someone more trustworthy. Now, if capacity significantly declines, there's a chance a person may not have the capacity to revoke their decision, but assuming capacity is staying the same, people can change their mind. And I think as a matter of practice, this is a good point to be raising with anyone you're speaking to when they're signing a document or they are having a conversation with you about participating in research or receiving care, is to remind them that they are giving you consent today, but they can change their mind and what they need to do if they want to change their mind, how they need to inform you if they've, or someone else if they've changed their mind. Consent can be given in many different ways. It can be provided orally. It can be done in writing. Sometimes we infer consent from conduct. To my mind, it's not necessarily the most confident way to be most confident that we've received consent, but for some people, that's the best way to do it. But for example, if you've had a conversation about giving them a blood test and what's involved, and then they hold their arm out that might be indicating their consent to receive that injection. Now, for some people with disabilities who have familiar nonverbal communication strategies, that are knowledgeable, that their friends and family know well, nonverbal communication may be the way they communicate consent. Inclusion and equality of access may require you, in some instances, to explore alternative ways of accepting communication of consent. Still, consent must be clear and unambiguous. I'd encourage you to trust your instincts, not your biases, but your instincts. If words say yes, but conduct suggests no, that is not consent. So make sure you are confident that yes means yes. And here I think the feminist community has taught us a great deal about consent. We know that no means no, but sometimes yes actually means no. And that's because folks are not feeling free or comfortable in expressing their dissent. Consent must be voluntary. It must reflect a true choice. In this sense, it is important to conduct your practice in such a way that people truly feel that they have a choice. Some people may have a hard time saying no to someone in a position of authority. Healthcare providers and academics can have enormous authority over people with less social power or education. Physicians in particular tend to command great respect. People who are people pleasers may have a hard time saying no to anyone. Consider, is there an honoraria for participation in your study? And how is that impacting the decision-making process, especially if there is a social equality issue? Is someone else maybe influencing decision-making? I would say that assent is not necessarily consent, and cooperation is not necessarily agreement. Sometimes getting consent will require us to have awkward or uncomfortable conversations with people when our kind of spidey senses are tingling that maybe the person doesn't agree, but their words are suggesting agreement. For example, if Eleanor comes to every meeting with Alice, getting back to the story of Alice, it may be difficult to determine Alice's true wishes. Although people with dementia may often prefer to attend meetings with a caregiver, especially because often you lose the right to drive. That's one of the first sort of rights people living with dementia face the loss of. So they're often not coming alone to places. It still may be prudent to have at least one meeting alone with Alice to get her true wishes and guard against someone else's influence that might be sort of controlling her choices. So that the notion of undue influence is when someone else is in a situation where someone is imposing their views over another. It refers to a lack of free will. I think it's very important to be alive to the risk of undue influence in your work, whether you are, a healthcare provider, a lawyer, a researcher, or just supporting someone in community as a caregiver. One of my colleagues has developed a fabulous 4-page reference aid for undue influence that you may find helpful. This is the cover of the aid on the slide you're looking at right now. The reference aid was developed for professionals who help people with wills, but much of the information in the aid is actually relevant to anyone wishing to enhance their practice with older adults or people with disabilities or anyone who might be vulnerable to abuse or undue influence or exploitation. The 4-page guide includes a number of really useful tips, and a few examples are, a one-on-one discussion with your client or the patient, the individual is always important. Group consent is going to be problematic. And also getting consent only with a second person in the room. So when we ask Alice for consent, we ask Eleanor or Stella to leave the room. But also if you're introducing a research initiative through a group presentation to say 20 people and talking to that group at once, you can't get consent from them as a group. You can't get proper consent from them unless you have a one-on-one conversation with each of them. Even if they have a group opportunity to ask questions, that group dynamic may impact people's ability to speak freely or comfortably. Sometimes asking questions makes us feel stupid, even if they are good questions. So meet with the person one-on-one to get consent. When you're asking questions, try to ask some non-leading questions so that you're really giving people a chance to speak their mind and you're not controlling the answer through the type of closed question you're asking. This is not The model of questioning is not the cross-examination you see in Perry Mason. Consider whether anyone might be dominating their decision-making, and you may be able to learn of this through their behavior rather than through their words, but it requires a certain amount of sensitivity. So just by way of review, I'd like to emphasize about 6 points that I think are the most key things I hope that you'd remember from this presentation. Capacity is decision specific. Always ask, capacity for what? Few people have capacity for nothing. Capacity is disease or disability neutral. A person may have capacity regardless of whether they are living with dementia or another disease or impairment that affects their mind and decision making. Everyone is presumed capable at law, but you must always check for capacity. Informed consent means making time for a rich discussion. It could mean having many conversations. Often you can't get consent out of one discussion. It's not unusual for people to write down questions after a meeting and come back. Letting people change their mind and making sure they know the possible risks of withdrawal from a program, an agreement, or kind of treatment. Being aware of power dynamics, dynamics of control and influence in particular. If you remember only a few things, I would say start with remembering these 6 basic ideas. I know I've said this before, but the law of consent was developed by judges through court decisions called the common law, and later refined and put into statutes in some provinces and territories. I encourage you to look at the resources developed by people who are working in the province or territory whose laws apply to your work. These tools, they will have publications that are specific to the jurisdiction in which you work. And so I'm just highlighting a few organizations. In BC, NIDA's Personal Planning and Representation Agreement Office has tons of brochures on capacity and consent that are very helpful. For in Quebec, Educalois has a number of resources that you may find helpful. For Ontario, I've reviewed many of the resources available on the website at the Advocacy Centre for the Elderly, and they are also excellent. There are tools developed to help us understand the law of many other jurisdictions. My experience, I think every jurisdiction has some agencies that's provided some information that's helpful and specific in this area, specific to that jurisdiction. So I'd encourage you to, in terms of doing your due diligence, whenever you're doing work, to do that research on the specific jurisdiction that you are working in. And the last slide here has our own website. All our publications are available on our website, and you can download materials for free. Some of our materials deal with consent and capacity. We are publishing a report on consent and capacity in BC in terms of the experiences of people living with dementia in the fall. So I encourage you to check that out, and hopefully we'll do a webinar specifically on that topic. You may have to get legal advice sometimes. Legal information provides you with a general understanding of the law, but it doesn't always tell you how to apply the law to your situation. So I would encourage you to get legal advice if that's appropriate. And happy to have a conversation to help you figure out if you need to get advice, but obviously my organization is not able to provide advice. So Crystal, that's really the summary of our presentation, and I'm happy to stay on the line and answer questions.
Thank you so much, Krista. So as Krista mentioned, she is happy to answer any questions. For anyone who is unfamiliar with the Zoom platform, there's just a Q&A box where you're able to answer questions. You can also, ask questions, and you can also put them in the chat box, and I will read them aloud for Krista to have. The first question is actually for both you and I, Krista, and I'm able to answer it, I think. It's from Audrey Miller, who asked if they can get a copy of all of your slides. And so I believe the answer is yes. So one of the things we do for all of our webinars is we archive them on both our YouTube page and our website, so you can actually watch the webinar back, or you can share it, and we will also make a copy of these slides available for anyone who wants to access them. And then for anyone who wants to participate in part 2 of this webinar, it will be on September 18th, 2018 at 2 p.m., the part 2. I will put a link in the chat box. Sorry, let me just grab a link for everyone, and I will, so that way you can all sign up. So for anyone who wants to sign up for part 2, you're able to do it by clicking the link that I just put in the chat box. Does anyone have any other questions?
And maybe just to add to that, Crystal, in terms of developing the content for the second webinar in September, the content isn't completely locked down. So if after this webinar people have questions related to consent and capacity that I haven't covered, you can feel free to email Crystal, and I'm happy to reflect on those in finishing up the content for the next webinar.
Yeah, that's a good point. I do think it would be good for people to ask questions, because I know a lot of people have general questions about this topic. So it would be good to frame the part 2 maybe more specifically on things that maybe questions people ask, not specifically answering, you know, in terms of representing them as a lawyer, but in terms of generalities and resources and things like that. So then one thing I also wanted to mention for anyone who wanted to see any of our other webinars, we have just actually launched our summer series. So our next webinar will be taking place on June 13th, and that will also be given by our Canadian Centre for Elder Law, Krista James, who's with us now, and she'll be joined by her colleague Valerie LeBlanc, and they will just be giving a webinar in recognition of World Elder Abuse Awareness Day. Following that, our July webinar will be on July 5th, and that will be given by Dr. Steve Rabinovich on predicting and preventing falls using technology. And our final installment of our summer series will be training the entrepreneurs of tomorrow, and that will be given by Richard McLoney, who is the Director of Entrepreneurship at the Impact Center, and they deal with a lot of entrepreneurship and innovation, as well as Dr. Pooja Viswanathan, and she is the CEO of an age-well startup, Brave Mobility. So I encourage you to sign up for those webinars and participate, and thank you everyone for joining. As Krista mentioned, if anyone has any questions, please feel free to email me. You can reach me at info@agewell-nce.ca. And if anyone has any other questions, I believe someone just posted a question in the chat box. So the question is, where do I sign up for the other webinars you listed? I will also post that you can actually go to our website. If you go to our website under news and events, there is the Age Well webinar series page, and you can sign up for each of those webinars there. So yeah, if anyone has any further questions, you can feel free to type them in the chat box. We still have a couple minutes.
And another thought, Crystal, too, is looking at the registrant list, I suspect that there are people out there listening who are aware of practice tools related to healthcare, consent, or other forms of consent that they might be finding very helpful, or they've developed themselves. I'm always happy to get emails from people linking me to other helpful tools. My email address is really easy to find on the CCEL website, so I just welcome messages with info and other tools. And if you have any feedback on the webinar, I always welcome constructive feedback. So
perfect. Okay, and I think we have another question. We have a thank you from the audience, and said that that was very informative. And I can see a couple people signing up for the part 2. So I think we'll leave it there. And if anyone has any other questions, you can always email either Krista or myself, and we'll be happy to answer them offline or continue it in our next webinar. So thank you everyone for joining, and have a good day.
thanks everyone.